Hi, we are going to begin the 55th session on IBC, specifically covering liquidation process, under which today we will be doing a deep dive into various timelines prescribed under IBC and also IBBI regulations governing liquidation process. Along with that, we will also cover what are the various forms that shall be filed by the liquidator during the process of liquidation with the adjudicating authority or other bodies. Before we get into the timelines and the forms, a quick recap on what we have done in the previous session. Regulation 40 to 46A is what we have covered. Regulation 40 tells you how to realize the uncalled and unpaid monies on account of capital by the liquidator. After that, we said all money should be deposited in the bank account and money should be spent from there. And after that, regulation 42 talks about distribution of monies from this bank account. After that, return of monies unduly received by any person. 44 talks about completion of the entire liquidation process within a period of 1 year. 44.8 says how do we treat the avoidance transactions. We said all those avoidance transactions should be accounted for and the asset should be brought into the liquidation estate. After that, we spoke about final report to be filed by the liquidator before the dissolution, and after that there are residuary regulations that talk about preservation of the records, then corporate liquidation account, and lastly exclusion of certain assets from the liquidation estates under regulation 46A. But exclusion of assets we've already read under IBC Act itself, under the provisions of the Act as to what will form part of the liquidation estate, inclusions and exclusions very clearly. So let's go forward and understand the timelines prescribed by IBC and IBBI together with reference to liquidation process of a corporate debtor. These regulations or these timelines are prescribed in regulation 47. The heading of the regulation 47 clearly states it is a model timeline. That means it presumes that the liquidation process begins on a certain day, which you call it as T, and if it is a T, within what date or within how many days from T are you going to do different actions. So we are going to take timelines as T plus 2 days, T plus 3 days, T plus 4 days, or T plus 10 days, or whatever it is, to understand after the liquidation commencement being T, within how many days we are going to do different events under the IBC liquidation process. So the entire process and the table explains you the timelines. Let's look at how to understand this. The first column here talks about how many items are there, serial number. This particular column talks about section or regulation numbers which give you a timeline, right? And it specifies what kind of a task is assigned under that particular section or regulation and what is the norm, right? So now, if I am looking at section 33 and 34 of the IBC, the task specified under 33 and 34 is commencement of liquidation and the appointment of liquidator. So what should be the timeline within which this should be commenced and liquidator should be appointed? Please be very cautious in understanding these things. As far as liquidation is concerned, the process of liquidation begins only on the order being passed by the NCLT. So that's the date of commencement of liquidation, and there is no timeline within which the liquidation should commence. Remember that. So the entire timeline henceforth is based on the preliminary timeline which is commencing of the liquidation process. So when does liquidation commence? There is no timeline, but once it commences, there are a number of actions that have to occur within the given timelines. Therefore, as far as commencement of liquidation and appointment of liquidator is concerned, We are calling this as time 0. So that is the event which will lead to the process beginning or commencement of the process. So therefore, the commencement, we are taking it as time 0 at which it begins, or t. From then onwards we will see within how many days what should be done. Let's quickly come to section 33 1b 2 read with regulation 12 sub-regulation 1 to 3. This talks about public announcement should be made by the liquidator as soon as is appointed as a liquidator. You remember that this is the announcement through which he invites claims from various stakeholders against the corporate debtor. Hence, this is a very important action that he is going to take soon after his appointment as a liquidator. But within what time should he actually publish this notice or make a public announcement in the newspapers? We are saying this should happen ideally within a period of 5 days from the date of appointment of liquidator. So if T is a time or date on which the liquidation is commenced, T plus 5 days is when you should have made your public announcement in Form B. I hope this is clear. Anyway, let's move forward to regulation 35 sub-regulation 2, which is third row in the table that we are seeing here. So what does it say? It says, when should I appoint registered valuers? Once the liquidation is commenced, we said appointment of valuers is inevitable and is absolutely critical for valuation of the assets, which will determine the liquidation estate value, right? So appointment of valuers is quintessential for you to complete the process. When should these valuers be appointed? So you can see that if T is a commencement of liquidation, plus 7 is when you should have made the appointment of valuers. So you are seeing that the first action only will get a little longer time. So the liquidator has a breather of 5 days to act. Once he has taken the first step of making the public announcement, the next step comes within the next 2 days. So there is no time for liquidator to sleep comfortably and keep on postponing things. Therefore, he has to plan meticulously as to how is he going to execute the liquidation process. Hence, as soon as appointment is made, he must first give a public announcement. Meanwhile, start collecting quotes from different valuers, understand who is going to do the valuation in the reasonable budget, basing on his estimate on the realizable value of the assets. Accordingly, he will fix up who is going to do the valuation and appoint the valuers within 7 days from the commencement of liquidation process. After this, we move forward to understand other timelines. So when should he have the first meeting of the SEC, which is given under regulation 31A. The first meeting of SEC shall be held within 7 days of the liquidation commencement date. So whenever we are saying LCD here, it is liquidation commencement date. Within 7 days therefrom, the first meeting of the SEC should happen. So if you recall, there is one action after 5 days, next action in the next 2 days, that is 7th day, and third action again on the same day. The third action is again on the same day, which is 7th day. So we have seen 3 actions till now. Now let's go forward to fourth action. The fourth one says, submission of claims or intimation of decision on relinquishment of security interests must be made by the stakeholders within a period of 30 days of liquidation commencement date. What are the concerned sections and the regulations? We've already seen that regulation 38(1) of the IBC talks about the submission of claims, also about relinquishment of security interest. Along with that, we've also seen Regulation 17, 18, 19, 20 and 21A dealing with the same subject matters. From here, we can conclude that T plus 30 is the time for submission of claims as well as intimation of decision on whether you're going to take the security interest with you or relinquish it in favor of the liquidator. Now we come to item number 5 here, which talks about section 38(5) and says withdrawal or modification of claim. We have already learned under section 38(5) that once a claim is made, he may also withdraw the claim or modify the claim within a time period of 14 days therefrom. So, if the claim is made within 30 days of T, the withdrawal or modification of claim can be made within T plus 44 because this 14 days time period commences from submission of the claim. Therefore, 30 plus 14 days is what you get to modify your claim, which makes it T plus 44. But submission of the claim, you will only have T plus 30 days. I hope it's clear. Let's move forward. Now, when we come to serial number 6, 7 and 8, these are dealing with different items. Regulation 30 specifically talks about verification of claims received under Regulation 12. So, how and when does the liquidator verify the claims that he received under Regulation 12? We said he shall verify these claims within a period of 30 days from the last date for receipt of claims. Alright, so obviously when I take T as a liquidation commencement date, what is the last date for verification of the claims made by stakeholders? We said T plus 6T is the date by which you should have verified the claims. Let's come to Regulation 31A, which talks about constitution of SCC. This should happen within 60 days of LCD, which is T plus 60, again the same timeline as we've seen here. Then we move forward to item number 8 here, which talks about section 40 subsection 2, which talks about intimation about decision of accepting or rejection of claim. We said once verification is completed here, the liquidator is bound to inform his decision to the stakeholders whether he is going to accept your claim or reject your claim or partially accept and partially reject. So this should happen within 7 days of the admission or rejection of the claim. Remember, T plus 60 is the last date for you to verify. Once you've verified, you made a decision, in the next 7 days you're going to communicate to the stakeholder. Therefore, T plus 67 is the time by which the stakeholder should have received a communication from the liquidator whether his claim is accepted or rejected. Let's go to next slide. Now we have item numbers 9, 10 and 11 dealing with Regulation 31, Section 42 and Regulation 13. So Regulation 31 says filing the list of stakeholders should happen within 45 days from the last date of receipt of claims. So what is the last date of receipt of claims? If you remember, T plus 30 days is the last date for receipt of claims, and from that day within 45 days you must actually file the list of stakeholders. So when I add T plus 30 plus 45, it becomes T plus 75, which will be last date for me to actually file the list of stakeholders with the adjudicating authority. Then when I come to section 42, appeal by a creditor against the decision of the liquidator when he is unhappy or aggrieved by the decision of the liquidator to either reject the claim in whole or partially, then such stakeholder whose claim is partly or wholly rejected will naturally have a remedy of going to the adjudicating authority and actually making an appeal against the decision of the liquidator. While the adjudicating authority is convinced that the decision of the liquidator should be reversed, it may pass an order accordingly, but the stakeholder who is aggrieved shall act within a time frame to actually proceed and file an appeal against the liquidator. So what is the timeline given for filing such appeal? This should be 14 days of receipt of such decision. So when should they receive the decision? We said in the previous slide that the decision should be made available within T plus 67. Now when I add T plus 67 plus 14 days here, which will become T plus 81. So the appeal shall be technically filed by the stakeholder within a period of 81 days from the commencement of liquidation with the adjudicating authority if he is aggrieved of the decision. Let's come to the last item here on this slide, which is serial number 11, regulation 13. It says preliminary report to the adjudicating authority shall be filed within 75 days of LCD. Now this is not connected to any other timeline, remember. The rest of them were connected to other actions and hence the time limits changed here. But when it comes to preliminary report, it should be filed within 75 days of the LCD. Hence the time limit here is straight away T plus 75 within which you should file the preliminary report under regulation 13 with the adjudicating authority. Let's move forward. So I'm sure you are understanding the chain as to what is linked to which particular event and how much time is given from that event for the completion of the next event, and which are all ultimately connected to the liquidation commencement date though, but some of these events are not directly connected to liquidation commencement date but are interconnected with various steps that we have seen so far. So let's move forward, understand what are there in item number 12 and 13. Item number 12 deals with regulation 34, which gives a task of filing an asset memorandum. So when should asset memorandum be prepared and filed? We said unless asset memorandum is filed and unless list of stakeholders is filed, the liquidator shall not distribute the proceedings to any of the stakeholders. If you remember that, therefore this becomes a very important precondition for distribution of funds to the stakeholders. So within what time should you file the asset memorandum? It says you can file it either within T plus 30 days or T plus 75 days along with the extension accordingly. Let's come to regulation 13. Item number 13, which deals with regulation 15, various sub-regulations within that, and finally regulation 36. So what is the description of the task here? It says you must keep on submitting progress reports to the adjudicating authority, asset sale report to be enclosed with every progress report if sales are made. This is a combination. So first you must file a progress report, and along with the progress report, whatever assets have been sold during that time, that asset sale report also should be attached and filed with the report of the progress, right? So what are the timelines within which you should file them and how it works? Remember, as far as these quarterly reports are concerned, progress reports, this is not connected to liquidation commencement date. Therefore, it is not T plus something. Instead, it is from the end of the quarter. So therefore, watch it carefully. When it comes to first progress report, it should be filed within 15 days from the end of first quarter. So let's take the example. If liquidation commences on April 1st, the first quarter will end on April, May and June 30th. So the first quarter ends on June 30th. Hence, within 15 days from the end of June 30th, you should file a first progress report. So when I look at what will be the date? The date will be June 30th plus 15 days, which is going to be July 15th, by which I file the first progress report if my liquidation commences on April 1st. Similarly, after that, every quarter you are going to file one progress report. Therefore, the time is from the completion of the quarter, Q1, Q2, Q3, Q4. And as soon as Q1 completes, within 15 days you have to submit the first progress report. Q2 completes, second progress report. Q3, third. Q4, fourth progress report. All of them should be within 15 days from the end of the quarter. After that, we are coming to one critical aspect which says that at the end of financial year, audited accounts of liquidators, receipt and payments for the financial year shall be submitted before 15th of April at the end of financial year. This is an important compliance. Remember, this is annually once only, but the rest of them are actually quarterly ones, which are progress reports, and other reports are actually one time basing on the event happening. But periodical reports are either quarterly basis or annual basis, remaining depending on how long your liquidation runs. As we remember, the entire liquidation itself should be completed within a period of 365 days or 1 year. Hence, probably this annual compliance also comes only once during the lifetime of liquidation of a particular CD. Maybe if the time is extended, there can be a second submission arising, but otherwise in one case, I guess there will be only one such report filed by the liquidator. So moving forward, let's come to item number 14, 15 and 16. Item number 14 deals with Regulation 15, and the task specified under Regulation 15 is to file progress report in the case of cessation of the liquidator. If the liquidator is no more occupying the position of a liquidator, is ceased to be a liquidator by way of a resignation or appointment of someone else, then a report shall be filed within 15 days of cessation as liquidator by the liquidator. So the target is date of cessation plus 15 days. Therefore, remember, here also we don't have the concept of T plus 15, but we have the concept of cessation date plus 15 days for liquidator to file his report. Then there is Regulation 37, in which we are talking about information to secured creditors must be provided. Within what time? We said it must be provided within 21 days of receipt of intimation from secured creditor about his taking away the security interest or renouncement of the security interest. The date of intimation, whatever is the date, from that date you have 21 days to communicate the matter to all other secured creditors. Let's come to next regulation, which is Regulation 42, Sub-Regulation 2. Accordingly, distribution of proceeds to the stakeholders. When should they happen? We've already understood this in Regulation 42 in the very session that we have done in the previous one, which is 54. We understood that within 3 months from the receipt of amount, the amount should be realized, right? Which is going to be date of realization plus 90. So to understand how does this timeline work, distribution of money is connected with realization of money. So unless there is realization, there is no distribution. So what we are doing is we are creating a nexus between realization of money and distribution, and also specifying timeline which begins from the date of realization, right? So if you have realized the assets on 31st of December of any year, within the next 90 days, say approximately 31st of March, the asset or proceeds must be distributed to the concerned stakeholders. This is how you understand the timeline as far as distribution to the stakeholders is concerned. After that, Regulation 10(1) talks about application to adjudicatory authority for disclaimer of onerous property. We have already read in Regulation 10 that onerous property can be disclaimed by the liquidator, but however, he cannot take a decision. He has to take a permission from the adjudicatory authority. So, the application with the adjudicatory authority must be filed within 6 months from the date of LCD. Now, typically again, this particular task is connected with the liquidation commencement date, and hence this is T plus 6 months or 180 days in terms of days. Let's come to Regulation 10 Sub-Regulation 3. Here it says, application to adjudicating authority for disclaimer of owner's property shall be made at least 7 days before making an application to adjudicatory authority for disclaimer. That means this you should make it to the stakeholders committee that I am going to disclaim the assets of the company, and after approval of the stakeholders you make an application to the adjudicatory authority. So if you have a plan to go to adjudicatory authority after 7 days, you better get the approval of the stakeholders at least 7 days before. Now we move to Regulation 44, which says liquidation of corporate debtor should happen within 1 year. Therefore, T being the commencement date, 365 days should be the conclusion of the liquidation. Then the last two items which talk specifically about model timelines. Now we are saying Regulation 46 says deposit the amount of unclaimed dividends or undistributed proceeds. You should know this. When I have a lot of money in my account as a liquidator to be distributed to various stakeholders, I'll make all possible efforts to identify the stakeholders and distribute this sum of money. But however, in spite of all my efforts, I may not still be able to identify a lot of stakeholders who would have changed their addresses, who are not traceable, or maybe some cases the shareholder or the stakeholder is already deceased. In all these cases, the amount of money remains with the liquidator, which is to be distributed to the stakeholders. That such amount is called as undistributed proceeds. What do you do with them? You should deposit them. Where and when? Before submission of application under sub-regulation 3 of regulation 45, the disclosure of the liquidation, you must deposit this undistributed money into a separate bank account and inform the adjudicatory authority. Here you see there is no timeline specified because this is before the submission of the application for conclusion of the liquidation proceedings. Now we come to the last item here, which is Schedule 1 of serial number 12. We come to Schedule 1, which is also related to serial number 12, time period to highest bidder to provide the balance sale consideration. How much time does he get after bidding for an asset to pay the balance consideration? We all know that he pays a certain advance amount, and after paying an advance amount, within the next some time he has to remit the balance amount to actually own the assets for which he has bid. What is the timeline within which he should pay the balance money? So we are saying the timeline is before submission of application under regulation 3 of 45, which is talking about conclusion of the liquidation process and commencement of dissolution. Hence remember that the highest bidder should pay the balance consideration as soon as possible, but not later than submission of the liquidation completion report. After that, we now deal with the filing of various forms. Regulation 47B of the IBBI liquidation process regulations specifically deals with only filing of certain forms, right? So here we have a table that talks about what kind of form is this, period within which the form should be covered, and the event and the scope, and the timeline is specifically given here. So if I am talking about liquidation 1, that's the form. Form liquidation 1 should be filed from liquidation commencement date till public announcement. This includes details of the liquidator, corporate debtor, the liquidator's fee, etc. on or before 10th day of the subsequent month after a public announcement has been made. Remember, once you make a public announcement, right, let's say you make a public announcement in the month of April, whole April is gone. We are saying before the commencement of 10th day of the next month, which is May 10, you must file certain particulars with the adjudicating authority in a certain form, which is LIQ1 or liquidation 1. So what details are you filing? You are going to inform the details of liquidation commencement date and till public announcement what had happened, like the details of the liquidator, corporate debtor, the liquidator's fee, etc. will all be mentioned here, and this form will be filed before the 10th day of the subsequent month in which the liquidation has begun. Let's go to next form. The next form deals with liquidation 2 or LIQ2 is the form. From public announcement till progress report. We all remember progress report is filed on a quarterly basis. The first LIQ1 is filed within 10th day of the subsequent month of the commencement of liquidation, but LIQ2 is filed, which includes details of valuation, sale, litigation, avoidance transactions, meetings of consultation committee, receipts and payments, etc. But this should be filed within 10th day of the subsequent month after each of the progress report to the adjudicating authority. So when is the first progress report filed? At the end of the first quarter, you file the first progress report. Now after that, in the next month, before the 10th day, you should file LIQ 1, 2, etc. Then if we go forward, LIQ3 will cover time frame or the events occurring between final report to application for dissolution from this date to this includes details of unclaimed proceeds, sale litigations, avoidance transactions, realization, distribution of proceeds and receipts and payments, etc. But when should I file this? This should be filed on or before 10th day of the subsequent month after submission of the dissolution or closure application before the adjudicating authority. So LIQ1, LIQ2, LIQ3 all are filed on or before the 10th day of the subsequent month, right, of a certain task. In the case of LIQ1, there is a different task, LIQ2, there is a different task, LIQ3, there is a different task. So after the task is performed, the next month, 10th is the target date for you to file the respective forms, and the time frame or information to be included within the form will span from and to the events specified here in this column, right? Let's go to the last of the slides for filing of the forms. This is LIQ4. The information contained in this or the data will begin from application for dissolution to order of the dissolution, and this includes details of distribution of proceeds, receipts and payments. When do you file this? This should be filed on or before the 14th day of passing of the order for dissolution of the corporate debtor or closure of the liquidation process by the adjudicating authority. So here the event dates are slightly different, and instead of 10th day it is going to be 14th day, but not in the subsequent month, in the same month on or before the 14th day of passing of the order of dissolution. Within that time you should file LIQ4. So friends, this brings us to the end of session 55, where we have discussed model timelines and also filing of forms under Regulation 47B, with various bodies by liquidator. To summarize what we have discussed today, Regulation 47 talks about timelines which we have seen beginning from T, which is 0, and closing till T plus 365, which is closure of liquidation. Then we have seen 47B, which talks about Q1, Q2, which is LIQ1, LIQ2, LIQ3 and LIQ4 forms to be filed by the liquidator. So in the next session, we will try and cover certain case studies to practically understand how the liquidation will happen and what are the challenges faced by the liquidator. Thank you.